Good afternoon, or are we? Yes, just afternoon. First of all, let me thank you sincerely for the organizers and the hosts of this wonderful event. And I feel honored that I can present you some practical aspects of the IPR enforcement of Hungarian customs. Hungarian customs has a specific situation with regards to IPR and its enforcement because three of our branches are related to this task. The border controls, of course, involve the customs procedures. We have the internal market control also done by customs in Hungary. And if we find something either at the border or inland which requires a criminal investigation, then the investigation service of the Hungarian customs is involved and leading the investigations. I won't bore you with the organigrams of our administration. We are much smaller than your administration here in Indonesia. And we only have two specific groups or teams dealing with IPR. And one is the competent customs department who are dealing with the application for action handling, just mentioned by Anna. And I will show you the importance of the airport customs directorate we have in a minute. And they have a dedicated team dealing with IPR. When we talk about customs enforcement, then of course, first of all, we need a legislation, a legal basis for it. That was just introduced by Anna in the previous moment. But we also need resources to be able to implement those regulations. And we need information for a decent risk management, about which I will talk about tomorrow. And of course, we need cooperation. I won't go into details to bore you again with Regulation 608. I just want to sum up that we find in practice, in real life, that indeed it provides for shorter procedures, reduced administrative burden, reduced costs, and increased efficiency. As mentioned before, customs enforcement can be based on application for action, or we can start ex officio cases. And these are related to goods suspected of infringing intellectual property rights. Goods must be under customs control or under customs supervision. So it implies that we are not only controlling IPR infringing goods in the import and in the release for free circulation, but all the other customs procedures can be involved, including transit. We also, sorry, I'm still here. We also have some exceptions, some of them similar to what you have here in Indonesia, and some of them are exceptional and different. When we talk about intellectual property rights, it has been mentioned in the previous presentations that customs has the right to enforce almost all of them, so to say all of them. But still, when we come to the practice, you will see that the majority of the seizures are related to trademarks. And this ratio of trademarks is about 85%. Even though the procedure would be the same, the simplified, but the knowledge and the willingness of counterfeiters to produce counterfeit goods is related mostly to trademark infringements. But now let's see some facts and figures about Hungary. This is the map of Europe. And as you can see, we are just in the middle with no seashores, no harbors. So we do not have big deep sea container vessel traffic. We used to have, and we still have, land road traffic, mostly from Turkey, coming to Hungary. And we started to have direct trains from China, but during the COVID, it reduced a little bit, and now due to the war in Russia and Ukraine, those trains are not coming anymore directly to Hungary, but indirectly. And of course, we have the main entry point via the air traffic, including postal and express courier consignments. It has been also mentioned, but we are also unfortunately involved in production of counterfeit products in the internal market. Yes, statistics. There is no presentation without statistics, sorry. And of course, we are expecting to see growing figures. But when we are talking about intellectual property rights enforcement, then the figures depend on so many aspects and factors. First of all, the products we find. It might depend on the transport mode, so we cannot expect the same amount of products or the same types of goods in postal consignments than in big containers. And of course, this transport mode also defines the quantity. As you can see, about almost 90% of all the cases are handled by the Airport Directorate of the Hungarian Customs Administration. This includes air cargo and postal consignments. You can see the figures here for air traffic and for the postal consignments. And you can see an increase in air traffic and a decrease in postal consignments. This doesn't necessarily mean that the postal consignments are not as important any longer this year than before. It just means that the same goods might have a higher value, and now they, when the customs declaration is presented for them, they fall under the air traffic and not on postal consignments any longer. And to have a look at the previous years we had, you see that there are some ups and downs. Last year was exceptional when we talk about the procedures and the number of articles seized during the customs controls. And the number of procedures is quite high this year. It's the last column, the first half of this year. But you can see the number of articles and the value is quite low this year. So we will see where we will end up by the end of the year. Yeah, top categories. Yeah, when we count the number of procedures, then we have most of the cases on toys. It has already been mentioned that it bears quite significant dangers on our health and safety, and especially of children. And the other categories in the top three for the procedures are clothing and sports shoes. When we bear in mind the number of articles detained, then the top categories are perfumes and cosmetics, clothing, accessories, and toys. And based on the detained value, of course, luxury goods come first, mainly watches, bags, and wallets. But toys are here again in the top three. Where do these goods come from? Obviously, most of them come from China. In the second place, you see Kazakhstan. It's strange. It's because of the trains. It's Chinese goods delivered on trains to Europe, and the customs declaration for the trains, the customs procedure of transit starts in Kazakhstan. Then, of course, we have Turkey and Hong Kong, just as mentioned in the previous presentations. And now, let's go to the procedure. Anna, before me, just mentioned you how the procedure is set up, what we have to follow. I would say it contains 4 major steps, and that's it. First, we have to have a suspicion, then we have to send the notifications, we have to wait for the responses, and based on the responses, we take a decision. It's simple as such. When can a customs officer have a suspicion? Obviously, only during a physical control. So based on documents, it's very difficult to have a suspicion when it comes to IPR infringement. Okay, but still, if the customs officer has the product in his hand, is it sure that he will have a suspicion? No, because he would need information, what to look for, what are the major trends, what are the major types of goods that are infringed. For this, they need training, they need information in the application for action included by the right holders. And of course, they need databases where they can look for information. And one of these databases we use is the IPAP from the EU IPO. The decision is mainly depending on the response of the right holder. So if the right holder says that the goods are not infringing, we cannot obstruct. We have to release the goods. We have to continue with the customs procedure. But if the right holder says that the goods are infringing, then we have 2 possibilities. Either they agree on the destruction or not. And if they don't agree on the destruction, then of course a legal procedure must be initiated by the right holder. So to sum up, there are 3 possible endings for a customs procedure: the release of the goods, the destruction of the goods, or a legal procedure. And even though this is not a complicated process, there are several tiny details that must be regulated as well. And some of these details are included in the regulation, the E608 as such. But there are some very general rules that must be followed, which are included in the European Customs Code itself. And there can be national provisions as well to tell the customs officer in the given country how to do certain steps of the procedure. For example, how to define the costs to be paid by the right holder, or which national databases to use. I will give you one example about the national legislations, for example, and it's linked to destruction. When the regulation 608 was put in place, and it took effect as of 2014, it gave a clear indication in which cases the destruction must take place, how it should be, how the goods should be destroyed is, of course, a national matter. In Hungary, we mainly use incineration, so burning, shredding, cutting, or breaking of the products. But there are some other aspects as well linked to destruction. Of course, it's the responsibility of the right holders. It must be performed under customs supervision. The cost should be borne by the right holder. But recycling is something which is decided on a national level. And also, the question of charity comes to the front every single time. Because people always ask customs, why don't you give the detained goods to charity? Why do you destroy them? It's such a waste. And we, together with the right holders, always claim that we do not know the source and the origin of those counterfeit products. We do not know which harm and which risks they are carrying. So we do not want the citizens to be put on risk that we don't know what they would receive as charity. And of course, we could do a laboratory test, for example, but imagine hundreds and millions of goods to be tested in a laboratory, which cost and time it would need. It's simply not workable. But back to the challenge with the destruction in Hungary. The national criminal code was constructed in a way that if customs had suspicion of infringing an IPR, it was obliged to initiate a court procedure and a criminal investigation. So it was completely opposite to what Regulation 608 now wanted, that we will leave the decision on the right holder and the goods should be destroyed. So, of course, before the regulation took effect in 2014, we had to do something. And seeing the possible efficiency and the simplicity of the EU regulation, we decided to amend the National Criminal Code. And here you can see the text of the new article, that it implies that when regulation, the EU regulation, is applicable, then customs has no powers whatsoever to initiate criminal proceedings. It's only upon the right holder to initiate the criminal investigation and the court procedure by a private motion. Here are some examples of destruction from real life. The UNO cards here are being shredded in this machine. And these are chainsaws. And another aspect I would like to go into a little bit more detail is the question of small consignments. Again, the regulation says everything you need to know about it. It's indeed a simplification, but in real life, it emerges some questions also for customs. For example, it can only be applied if the right holder is requesting it in the application for action. Unfortunately, what we see in real life is that not all or only a limited amount of right holders are asking for this simplification. Why? They always claim they need information, and the information they can receive is coming from the notification we send them. So that's why they are mostly reluctant to ask for this small consignment procedure. There are even certain right holders who apply a certain threshold. So they say that if it's 1 or 2 pieces or below 10 pieces, below 100 pieces, they are not interested. They won't take action if the number of the products is limited. Sad, but true. The costs. If the right holder is not notified when there is a detention, but suddenly receives an invoice from customs for the storage, for example, that please pay the cost for the storage, there is a missing piece of information for the right holder, so he doesn't even know about what he should pay the storage cost because he was not informed of the detention. And it's same or similar with the destruction. In Hungary, normally we ask the right holder to organize the destruction. For big containers, it's working perfectly. But for small consignments, if they don't know about the detention because they were not notified, they cannot arrange for it. So what we are doing at the airport customs directorate, where we have these small consignment procedures taking place, is that every month we organize one day where we invite the representatives of the right holders, and we claim that this is a day of destruction. And the right holder representatives come to our warehouse with their scissors or hammers, whatever is needed to the goods that are collected in the warehouse for that month, and they destroy the goods themselves. Easy as such, small amount of products, easy to destroy them, and there are no costs whatsoever. So I already mentioned that the customs officer, to be able to have a suspicion, of course, needs a thorough training. In Hungary, we have a basic IPR training involved in the customs training curricula in the customs school. But also this is, first of all, very basic and mainly theoretical information. So we need some more practice. We need to see the trends. We have to be updated from time to time by the right holders to have the up-to-date information at hand. That's why we organize 4 times a year a seminar where we involve the right holders. We invite them to give presentations and show us the latest news. A couple of years ago, we organized thematic seminars as well, once a year. So we had one for medicines, one for foodstuffs, cosmetics, car spare parts, IT, and sports for the sports industry. Unfortunately, due to resource constraints in the last years, we couldn't arrange such thematic seminars, but we are planning to do some more. And of course, our officials have the opportunity to participate in international trainings, mainly organized by the EU IPO or DG TaxSud. Both of them have e-learning tools. I'm sure we will hear about them later. Just to give you some ideas how our trainings look. So first, they have a more theoretical part with the presentations from the right holders. And we also have some tables arranged where the right holders can bring original and counterfeit products, and the customs officers can take these products into their hands. And it's much easier to learn the difference between an original and a counterfeit products when you can touch them, you can feel them, you can see all the labels, and you can have a chat with the right holder representative. We also use, of course, information sources. For the legislation, it's EURELEX. We have the lead platform of CEPOL, where the EU IPO learning material can be reached. Actually, side information, the CEPOL has the headquarters in my country, in Budapest. And we also use the customs website and other internal channels to provide information to the customs officers. But we are not only providing information for the customs officers, but also for the audience, for the consumers. And this is done by our website or in the media. It can be for big seizures. We give a press release. We are present in different fora of the social media. And we also have an application for mobile phones. We have an information desk at the airport for travelers. And my administration is always present at the biggest events and festivals organized in Hungary, and the expositions. Actually, that's me in the biggest youth festival in Hungary, which is the Sziget Festival. And actually, I think it's just closing this year's edition today or yesterday, I don't know. And we also have press conferences together with right holders about the bigger destructions. So, to sum up some of the challenges for which I don't necessarily have the solution, but I open the floor. If you have solutions, we are eager to learn. So the first is, of course, the spread of e-commerce. It's really flooding us. And the other problem we have, as mentioned before, is the counterfeit products being produced in the EU. Another issue is the active involvement of right holders. Also, I refer back to the fact that not all the right holders have an application for action in itself, but if they have, they might not ask for the small consignment procedures. They might not indicate all the necessary information which we could use for risk analysis, or some of them even have the thresholds below which they don't want to take action. Concerning the internal challenges, we of course have our priorities defined by the highest levels, and unfortunately IPR is not necessarily in the top of this list of priorities, and that's why we might not always have enough or sufficient resources allocated to this task. As I mentioned in the beginning, we have 3 branches of customs dealing with IPR, and there is still room for improvement for internal discussions and information sharing, I have to admit. And we could make better use of the IT tools and information systems we have at hand. And of course, there is always room for improvement for risk analysis, of which I will talk about tomorrow as well. And to close my presentation, I will give you some examples. As mentioned, the toys are in the top 3 in every aspect what we see. So here you see some examples of toys, perfumes, again, always on the list. Shoes, most of the time sneakers, training shoes, but some other shoes as well. Some technical products, and here I give you some examples that it's not always the luxury brands and the tools that you would think are counterfeited that you find. So these handheld machines are also in our view, and of course car spare parts, but luckily it's mostly the less dangerous parts. It's mostly emblems and stickers. But I don't have to emphasize that the high-end luxury brands are always in our radar. And at the end of my presentation, I thank you for your kind attention with my favorite picture of the Louis Vuitton dog. Thank you very much.